This program is brought to you by Emory University.
Welcome to the 15th Annual Legal Ethics and Professionalism Symposium. As all of you know, the theme this year is the crossroads or the intersection of ethics and immigration law. And this particular panel will be dealing with the issues of criminal law and immigration law and where they intersect. And we have a great panel for you today. Unfortunately, we had, until maybe about 30 minutes ago, had the district attorney from Gwinnett County, Danny Porter, who was going to be serving on this panel and give us the perspective from the prosecutor's role. Unfortunately, he got tied up, and then traffic on the way here was unbearable, and he's not going to be able to make it. But I believe that with the panelists that we do have, we will be more than able to cover the issues addressing criminal law and the intersection of immigration law. I first want to introduce our two panelists that we have here this morning. The first is Jason Cade. Jason is a professor at the University of Georgia and teaches immigration law there, and he directs the school's Community Health Law Partnership Clinic. Jason's current scholarship focuses on the intersection between immigration enforcement and criminal law, and his articles have been published or are forthcoming in the Columbia Law Review Sidebar, the UC Davis Law Review, the Tulane Law Review, the Cardoso Law Review, and the Harvard Latino Law Review, and the Brooklyn Law Review. So Jason is a true scholar. He writes a lot on these issues, and he should have some great information for us this morning. Seated next to Jason is my good friend John Sperling. He is a criminal defense lawyer, and I should turn this off. I apologize for that. He focuses his practice on criminal defense and deportation defense. He's been doing that for over 15 years. He does a lot of post-conviction relief. He is the go-to guy when folks have immigration and criminal issues. As a way of introduction for myself, I was a judge, but and I'll tell you about that in a minute, but John is just a great guy, knows a lot about a lot of practical information that you'll have with us today. I am Tony Del Campo. I didn't introduce myself. I was a trial judge for nearly a decade here in DeKalb County in downtown Decatur, and I dealt with a lot of these issues in my courtroom. When immigrants, as many of you know, DeKalb is a very diverse county. And we saw, and I saw, people coming in, and oftentimes our lawyers were unaware of the ramifications of a criminal plea to their immigration status. And those were issues that were very important, and when I would ask about it, oftentimes they wouldn't even know that there was an issue. And so it's important that for those of you who are practitioners to know what those ramifications are. But by show of hands, how many of you here practice criminal law? Okay. How many of you practice immigration law? How many of you do both? Great. Good. Then we have a great audience for this particular panel. So let's get right to it. First, Jason, I'd like for you to talk to us about, the intersection of immigration law and criminal law, and when does it come together? When does it become relevant, in essence?
Sure, Tony. And first, I just want to thank Silas Allard and Emory Law School for hosting this event, and very glad to be here to talk about these issues. So, I think given the kind of different backgrounds of the audience members, I'm going to talk generally about how immigration and criminal processes are intertwined. Everyone who lives in the United States, every foreign-born person who's residing in the United States does so sort of along a continuum of legal status. So, of course, you have naturalized citizens who have exactly the same rights and privileges and duties as citizens who were born in the United States. And then right next to those folks are lawful permanent residents. So those are folks who are lawfully present, who are expecting to reside in the United States permanently. and have many of the same rights and privileges as U.S. citizens, but not all of them, and as we'll talk about today, they can be deported for various reasons. And then sort of at the other far end of this continuum, you have undocumented persons who either have overstayed visas or have crossed into the United States illegally, and as a consequence are removable, deportable, just based on that fact alone. Although for those persons too, their interactions with their criminal justice system are very, very important. And then in between undocumented persons and lawful permanent residents, you have just a huge range of legal statuses. So you have some folks who might be here on temporary protected status because the conditions in their country, there might be a natural disaster or something that's something that allows the government to give them permission to stay here. You have persons on work visas, student visas, and so on. For all of these persons who are not citizens, interactions with their criminal justice system today are likely to lead to some kind of immigration consequences. So, and that's because in recent times, there's been a criminalization of immigration, of immigrants and immigration crimes, and the two systems have become intertwined in very, very intricate ways. So, one of the changes that's occurred in recent decades is making most criminal convictions lead to some kind of immigration consequence, even for lawfully present non-citizens. And I'll talk a little bit more about that in just a second. And then the other reason, the other way that immigration and criminal enforcement have become very intertwined now is through an integration of the enforcement systems. So we have many federal programs that give the federal immigration enforcement agents access to non-citizens who encounter criminal justice systems. And we also have many states like Georgia and others who have passed their own laws that make immigration a piece of the criminal enforcement by the state's own law enforcement officers. So because of this, almost any time a non-citizen encounters the criminal justice system, there's a very, very high chance that they're going to end up at least being screened for the potential referral to immigration court and possible deportation. If they're one of those persons who are already undocumented, just the arrest alone, or if they're already removable for any reason, just the arrest alone means that they probably will end up in deportation proceedings. And maybe we'll talk a little bit more about how that happens later.
Is that the 287 programs?
Yeah, well, there are several programs, Tony. So actually the most important one now is a program called Secure Communities. And Secure Communities is a data sharing program between the FBI and the Department of Homeland Security. And so basically what happens is that anytime a person's arrested, when their fingerprints are, by local officers, when their biometric data, their fingerprints are sent to the FBI to check for outstanding warrants, which happens in every case, the FBI forwards that information to the Department of Homeland Security, and someone looks at a screen and checks some records, and if it looks like the person is deportable, either because of the charge, or potentially deportable, either because of what they've now been charged with in the criminal process, or just because they've overstayed a visa, or if there's another indication that they might be removable already, then the Department of Homeland Security issues something called a detainer or an immigration hold, and that asks the local authorities to keep the person in custody at the time that they might have been released until the Immigration and Customs Enforcement has a chance to come and pick them up and do their own screening.
Now, do the cities have to opt into that program? Because I want to say Fulton County or the city of Atlanta just recently opted out of that.
Well, you can't opt out of Secure Communities. So the only way you could not comply with Secure Communities is not to check to see if the person that you've arrested has any outstanding warrants, and no law enforcement agency is going to do that. You can elect not, a local government could elect not to, or a law enforcement agency could elect not to comply with the detainer request. So you might, and in fact, you know, some cities, some counties throughout the United States and even the entire state of California have limited their cooperation with those detainer requests in certain circumstances, typically involving situations where the person was arrested for fairly minor offenses and doesn't have any kind of significant criminal history behind them.
John, what's your experience with that? Have you seen that in Atlanta, and the counties or municipalities are participating or not participating in those programs?
There are definitely some counties that are a lot more active in secured communities and 287G, specifically Cobb County, Gwinnett County, Hall County, Whitfield County are counties that actually have a 287G program and who have immigration agents that are either housed at the jail or some deputies that work at the county level that are deputized by ICE and that are basically given immigration agent roles and that have the ability not only to identify foreign nationals who don't have status, but also to place immigration holds or immigration detainers on people. Other counties that don't have 287G, depending really mostly on funding and also perhaps the immigrant population in those specific counties may not have specifically a per se 287G program, but also have a very active relationship with ICE. And most people that run through those jails will probably end up with an ICE hold. For example, Clayton County, Fulton County, DeKalb County, Houston County, which is south of Macon, are counties that have large immigrant populations, and that although they don't specifically have a 287G program, they're still very active and really very aggressive in how they identify and move to deport foreign nationals.
Now, these holds, are they placed mostly on folks who are in the country without proper documentation? Is that fair?
Yes and no.
Okay.
Something that is extremely frustrating is that people who have legal status may very well end up with an immigration detainer. I've got a client that I'm representing right now in Hall County who has had an employment authorization card for 3 years. She is what's called a VAWA recipient. She's a female. She received her employment authorization as being the victim of domestic violence out of a abusive relationship. She is currently charged with a simple battery against her live-in boyfriend. She's got an immigration detainer. I've been begging the ICE agent at the jail to please remove or lift the immigration hold because I am afraid of posting her bond and having her go to ICE custody and getting stuck in limbo. And limbo means that you are no longer at the whole county level where I can represent you and hopefully get the charges dismissed or reduced, but rather she could potentially go to ICE custody and she could potentially be held in ICE custody based on the pending criminal charges, and by the person posting bond at the criminal level and going to immigration custody, it makes my job of trying to get the criminal case resolved successfully much more difficult, since I lose the leverage of having the person at the county level to be able to fight the criminal case. Very frustrating circumstances, and like I said, this lady is here with legal status.
Jason?
Yeah, I mean, and of course she could be transferred to some other part of the country once she's only in ICE custody, which makes it very difficult to represent her. Yeah, so just to back up slightly and just make sure we're all on board with these three different types of enforcement programs we've talked about. In addition to secure communities, we've been talking about the 287G program, which is where the federal government actually trains local law enforcement in the enforcement of immigration law and sort of deputizes them to make immigration arrests and do immigration investigations and enforcement. And then we have various programs that actually place immigration enforcement agents in local jails, or give them access to local jails through video conferencing or through the manifest lists of who's being held there. And so they can do interviews to try to determine whether a person should have a hold placed on them. So to circle back to the question you asked a moment ago, Tony, who does this affect? It really affects anyone who's the government believes might be deportable. So we've been talking a lot about persons who are undocumented and deportable just on that basis alone because they've violated a visa or so forth. But most of what we're going to talk about today is how this affects lawful permanent residents and other persons who are deportable, who might become deportable if the end of the criminal process results in a certain kind of conviction for them. So what kinds of convictions matter here? I mean, really, almost any conviction leads to some form of an immigration consequence. In addition to deportation, when you get convicted of an offense, you might be subject to mandatory detention. You might be subject to discretionary detention unless you can post what's typically a very high immigration bond. And you also might never be able to adjust your status lawfully in the future or to lawfully re-enter the country after you've been removed. And later, John is going to talk about some of those details and how they matter for the criminal defense attorney who's representing one of these persons. So of course, sometimes the convictions are very, very serious ones that maybe many people or most people would believe should lead to deportation. There's a category of removal called the aggravated felony, and it includes very serious crimes like murder, rape, trafficking in drugs, trafficking in firearms, and so forth. But an aggravated felony is a technical term, and it actually includes crimes that are. It also includes crimes that are neither aggravated nor felonies. So it's if you have any kind of crime of violence, so maybe a domestic violence offense that includes a 1-year sentence, even if that sentence has been suspended, that's considered an aggravated felony. If you are a recidivist marijuana possessor and you're charged as a recidivist and you get at least 1 year of jail time or a suspended sentence, that's considered an aggravated felony. So many minor, what might be considered by many people to be minor offenses also fall into this aggravated felony category, which is really important because the aggravated felony category carries the most severe immigration consequences. When you are convicted of something that is deemed an aggravated felony, you have almost no chance to defeat deportation. So there's almost no discretionary relief that an immigration judge could later find you eligible for to prevent to stop your removal from the United States, and you are permanently barred from ever returning to the United States again if you have an aggravated felony, and you're subject to mandatory detention. There, of course, are many, many other categories of convictions that can lead to immigration consequences. Crimes involving moral turpitude, just all but the most minor drug possession crimes. Domestic violence is its own category for removal, and many more. But except for the aggravated felony, most of these, at least in theory, preserve some chance in the future for an immigration judge to find that you might, to balance the equities in your case and find that you might not be subject to removal. Of course, I don't want to make it sound like that's easy to get because under current law, it's discretionary relief from deportation is very challenging. In most cases, requires having been in the United States for a fairly long period of time and being able to show that your removal would cause a very high level of hardship to another U.S. citizen or lawful permanent resident.
All right, so obviously sometimes it can be counterintuitive. What's an aggravated felony because for purposes of criminal law, you would think that a misdemeanor domestic violence may not necessarily be an aggravated felony, or a, possession of marijuana charge or anything like that. But so that creates some challenges for the criminal defense lawyer. In other words, you have to know what charges are deportable and what charges aren't deportable in order to be able to advise your clients. And so to you, John, how do you view your duties as defense counsel when you are representing an individual who is here either as a legal permanent resident or maybe a DACA student or somebody who's not necessarily just here without any proper documentation?
From an ethical perspective, as lawyers, we have a number of duties. And some of those duties are obviously very clear, right? Don't cheat, don't steal, don't lie, obvious duties. We also have a very important duty to be effective in how we represent our clients. And effective assistance of counsel is obviously a constitutional right, and it becomes a duty that we have to try to be effective. Now, in trying to determine what is effectiveness? Well, I think that we would all agree that as lawyers, we are hired by our clients to solve problems. And those problems vary greatly depending on who the client is and what issues they are faced with. To give you an example that has nothing to do with immigration, I do very serious felonies, but I also do a lot of traffic violations. And I've got a bunch of clients that are truck drivers that have CDL licenses. They're U.S. citizens. They have nothing to do with immigration and who come to my office with a traffic violation, and my job becomes to give them meaningful representation. And what does that mean for that truck driver? Well, it means that I'm going to try to keep your CDL license from being suspended. And whereas somebody else who has a regular license, would not be subject to the same consequences of losing their job as a truck driver, and my representation of a guy with a little speeding ticket would be completely different than my representation for the truck driver who makes a living driving and who needs his CDL. Well, that determines the meaning or the importance of my representation for that guy. Well, when I represent a foreign national, the meaningful representation for that guy is completely different than for a U.S. citizen. And the meaningful representation for that person who may be either A, a legal permanent resident, B, somebody that has a lower level or a lower grade of employment authorization, C, could be somebody who is here legally on a tourist visa who doesn't want to lose their tourist visa. D, could be a student who is here on a student visa. And there are multiple, or E, could be somebody who doesn't have status, let's say, who is considered currently undocumented, but who wants to legalize their status through marriage, for example. That person has a huge interest in receiving meaningful representation at the criminal level to protect their immigration status. Now, what makes it difficult, and it is very difficult and very complex, is that the person's specific status at the immigration level is what drives what the ultimate result has to be at the criminal defense level. And I've been doing this for 15 years, and I promise you that at some point in time in my practice, 14 years ago, I felt shame in how I represented a client. The client was a little Salvadoran lady who was charged with traffic violations. And she had a DUI, no insurance, and other traffic violations. And I did not realize at the time, I was a year out of law school, trying to build a name in immigration/criminal law, that she had a type of status called TPS. And TPS is, for those of you who don't know, it's called temporary protective status. It is a very sensitive type of status that allows people for certain countries to maintain lawful status. Unfortunately, TPS is canceled if the person is convicted of 2 misdemeanors. And those 2 misdemeanors may arise out of the same set of circumstances, and shockingly to some people, 2 misdemeanors may be a no license and a speeding ticket. You've got two citations, you plead to both citations, you lose your TPS. Well, that's exactly what I did. I pled I got a reckless driving, amazingly, on the DUI. I was really excited. Man, I did a great job. I got rid of your DUI. And I pled guilty to reckless driving and no proof of insurance. And what I thought was a great job turned out to be a really crappy one. And this lady received a notice. She got her TPS, was being canceled. And to be honest with you, I made an immediate phone call to an immigration lawyer friend of mine who said, oh my God, I screwed up. What the hell do I do? And next thing you know, I was calling a friend of mine, another attorney, who was filing a habeas where I stood up and said I was ineffective as hell. And thankfully, the lady's plea was vacated and she kept her TPS. What is my duty? Well, my duty is to know what I'm doing. And my duty is to inform myself to the extent possible, and I use the word possible because we are not all born knowing and we don't pass the bar and are effective immediately. My duty is 3 things. Number 1, I'm going to do the best that I can to learn what I need to know to be effective in the relationship between pardon me, criminal law and immigration deportation. Duty number 1. Duty number 2, when I don't know the answer to the question, I'm going to call somebody who can help me. And after 15 years, I'm a so-called expert in the subject, and I say so-called because I promise you, I have relationships with great immigration lawyers who I am not afraid nor embarrassed to annoy regularly and say, you know what, I think I know the answer to this question, but I don't. Can you help me? And I promise you that as part of my duty, I'm in private practice, I'm in business. The reality is, I'm in business and I have paying clients, and business relationships are very important. And I promise you, for those of you who do criminal law and don't know much about immigration, your duty is to either learn it or call somebody who knows it, or to develop a relationship with an immigration lawyer who you can say, look, I will send you business, which I promise you will be very welcomed, if you help me determine what the objective should be in me representing A client, B client, C client. And what you do, and you can do successfully if you don't care to learn it as much as I did or others did, is you associate an immigration lawyer, or you call an immigration lawyer who tells you this is what you need to do to try to protect that person's immigration status. Now, you could look at me and say, well, Mr. Sperling, you know, why should I learn immigration? I'm a criminal defense lawyer. You know, I'm not an immigration lawyer, nor do I care to be. Well, the duty to know immigration, at least to the level of being able to advise your clients, doesn't come from me, I promise you. It started in 2004 in Georgia with a case called Rollins v. State, Georgia Supreme Court case. I've used it for many years very successfully in post-conviction related cases. Rollins is a case that originated in Gwinnett County, where the lawyer that represented that person advised the defendant. She was a young lady charged with possession of cocaine, and the lawyer told her that if she pled guilty under the Georgia First Offender Act and completed her sentence successfully, she would not be deportable. Years later, Rollins was now faced with deportation proceedings as a result of her plea of guilty to possession of cocaine, and the Georgia Supreme Court ruled that affirmative misadvice to Rollins, to the extent that she would not be deported if she pled guilty to possession of cocaine under the first offender, would not make her subject of deportation. And basically, the Georgia Supreme Court vacated or reversed the trial court's denial of her habeas corpus petition.
Did the court in that case, in essence, say that was ineffective assistance of counsel?
That was the trial court denied the habeas corpus petition, saying that immigration consequences were collateral, and that collateral consequences were not a legal basis to vacate a criminal conviction. Georgia Supreme Court disagreed, reversed.
Was that the first time that the Supreme Court, in essence, said the immigration consequences of a plea are not collateral?
There is a prior Georgia Supreme Court case called Kolak v. State. It's an unpublished opinion. It dates back to 1999, 2000. I started practicing in 1999. From 1999 to 2004, I used Kolak. Kolak was an unpublished opinion, didn't really carry that much weight, but it definitely opened the door. After Rollins, we had a period of 6 years, at least here in Georgia, where Rollins was basically the state of the law. And Rollins defined the lawyer's duty. And that was, you did not have to know immigration law to advise your clients, but you had a duty not to misadvise. In other words, you could remain silent and not talk about immigration issues so long as you did not stick your foot in your mouth and said, listen, if you plead guilty, you're not going to be deported. Well, Rollins said you were ineffective in that regard.
How about, were there other subsequent cases that then said that you had an affirmative duty to give advice?
Absolutely. We fast forwarded to March 2010. We got Padilla versus Kentucky, U.S. Supreme Court case, absolutely wonderful case, wonderful for the immigrant community, perhaps a challenge for the criminal defense lawyer community. And Padilla raised the bar requiring lawyers not only to provide, providing lawyers not only to not provide misadvice, double negative, but raise the bar requiring lawyers to provide affirmative advice to the immigration consequences of their plea. In other words, now as a lawyer, you not only have a duty to not say something that's not correct, but you have an affirmative duty to inform yourself about the immigration consequences of the plea so that you can advise your clients in the affirmative if they are going to face potential immigration consequences. Now, the one thing that I love about Padilla is that it has very strong language to the extent that when the immigration impact is clear, the duty to advise your clients is equally clear. And if you ask yourself the question, well, when I help a person, when I represent a person, is my advice sufficient for me to be effective? The answer is advice is nothing without our affirmative action to help the client. I could tell somebody, listen, you're going to prison. I'm representing you in an armed robbery and you're going to prison, but I'm not going to be effective by just merely telling the guy it's an armed robbery and you're going to prison. How am I going to be effective? Well, I'm going to represent you aggressively, zealously, and I'm going to try to get you the best possible deal that I can, even though you're charged with armed robbery. Well, in the immigration realm, my duty, I would say, is the exact same. Not only do I have a duty, from my perspective, to advise people of the immigration consequences of their plea under Padilla, and Padilla is very clear, I do, but I am going to take that duty a step much further, and I'm going to say, if I've got to advise you, my advice is meaningless without my effort to try to keep you from being deportable or from being inadmissible. And for that, I go back to what I suggested earlier. Either A, I learn it, which I continue to learn 15 years later. I promise you I don't know it all. I probably will never know it all. B, I make a phone call and I get advice from an immigration lawyer who does. Or C, I associate an immigration lawyer into the case, assuming that the client can pay, of course, in the hope that we can work together in providing that person with what I would consider effective assistance of counsel.
Now, Jason, let me ask you this. Let's assume that an individual is represented at the trial level and enters a plea in a situation where the lawyer perhaps has either given misinformation or has not given any information with regard to immigration consequences. What are the post-conviction relief options for the immigrant?
The post-conviction relief options.
Why don't we try to get Jason in on, or would you rather?
John can take this. I mean, this is where he works.
Bailiwick. All right.
Yeah, you want to? Well, I was gonna say something.
Sure,
I was gonna comment on something John had said, though.
Yeah, go ahead.
So I find it. I mean, in some ways, I think what John said is very important. That your duty, or the defense attorney's duty, under the Sixth Amendment, maybe encompasses something more than just giving accurate advice about the immigration consequences. That it also includes acting on your knowledge about the immigration consequences to deliver the best possible representation to your client depending on their individual circumstances. And this is, in some, I think you said, John, that this was going many steps forward or something like that, but I'm not sure that it's actually that much, that it's very far beyond what the Supreme Court intended with its decision in Plea v. Kentucky. And throughout that decision, you can see that the court very much had on its mind the proportionality concerns between culpability and the total package of penalties that flows from a conviction. So the court, it eschewed this idea of collateral consequences, and it didn't exactly say that all immigration consequences are direct, because they're not all direct, but it did categorize the immigration consequence as a penalty rather than just a collateral consequence, and a penalty that's in many, many cases one that's going to automatically flow from the criminal conviction. And so in the opinion, they had this language that I want to read, which is they said that counsel who possess an understanding of the immigration consequences of a particular offense may then be able to plea bargain creatively with the prosecutor in order to craft a conviction and a sentence that reduce the likelihood of deportation. For example, by avoiding a conviction that triggers automatic removal as opposed to one that preserves the possibility of discretionary relief. And so if we could, maybe we could stick with this for just a little bit before we get into post-conviction remedies, because I'm interested in, I think it's worth airing a little bit what that kind of the range is, or what the possibilities are for this kind of creative plea bargaining and what it entails. Yeah.
That's a great point, and unfortunately, Danny's not here with us. I was hoping so he could give us some insight as to what are the things that a prosecutor can and can't do, either from an ethical perspective or sometimes even a political standpoint, with regard to entering plea or giving plea bargaining. So, John, obviously you are the expert here on dealing with those discussions and plea bargaining prior to the plea. I would imagine that does play a factor in the recommendation and in your negotiations with the prosecutor. How do you handle that?
There's a saying in life that if you don't ask, you don't get. And it's amazing sometimes what you can get in life, in business, and in law by merely knowing what you want to ask. And if, to give you an example, lady gets charged with misdemeanor shoplifting. She steals $10 worth at a store. She goes to court either pro se, pleads guilty, gets 12 months probation, or she is represented by a lawyer who doesn't know immigration-related issues, and she does the same. She pleads and takes 12 months probation to a shoplifting charge. What just happened is, and I promise you I cringe every time I see it happen, and when I can, I step in and I try to avoid it, but she just became an aggravated felon. And amazingly, an aggravated felony, as Jason was telling you a little while ago, is amazingly the same as being convicted of murder or trafficking or rape. And her immigration consequences for the $10 item that she took from a deportability perspective, from a mandatory detention perspective, are going to be equally the same at the immigration level. So what would I do, or what should you do? Well, certainly we want to avoid that lady from being an aggravated felony. Well, that's the obvious answer. But in approaching a prosecutor, what needs to drive what you ask or what you request is going to be how would I provide this person with meaningful, effective representation? To give you 4 options in that example, to answer Mr. Del Campo's question a long way, but number 1, you can ask a prosecutor to do pretrial diversion. Pretrial diversion is a program, wonderful program, that most counties have that allow a person who doesn't have any significant criminal record to do some things, fulfill some conditions, such as a class, community service, and the payment of a fee. And if that person fulfills those obligations through the program, the charges get dismissed. Are prosecutors open to that idea? Absolutely. Another thing that you could ask would be to reduce the charge. Assuming, let's say that that lady had a DUI, and let's say that because of that prior DUI, that lady is not eligible for pretrial diversion. Why? Because this is not her first arrest. Then you would ask for a reduction in the charges from a shoplifting to a lesser charge of disorderly conduct, perhaps criminal trespass, perhaps loitering, something else that would not trigger the same immigration consequences of the plea. Third example, prosecutor is absolutely not willing to reduce the charge. You're stuck with a shoplifting. Has it happened to me? Absolutely. Lady is on video. She has a prior conviction for something else. I can't get rid of the shoplifting. There is no way that I can win a trial. What am I going to do? I'm going to ask a judge like Judge Del Campo to give me a sentence of less than 12 months. Sometimes the prosecutor will agree, and I like being able to reach an agreement with the prosecutor because it reduces my risk. But in the event that the prosecutor is not willing to reduce the charge and he's not willing to reduce the length of the sentence, I'm going to do a non-negotiated plea before the judge, and hopefully the judge will agree to reduce the length of the sentence. And what's interesting is that when I moved to the South, I've got an accent, as probably you guys can tell. I thought that my accent would not be received well, and it's amazing how my accent actually triggered judges to say, where are you from? Where were you raised? And along with that comment, is amazing how sympathetic older Southern judges are to hardworking immigrant people. And I can tell you, it's something that I've been fascinated for many years, how willing, amazingly willing, some judges are, many judges are, most judges are, to give you a sentence that in some circumstances, not all, will help your client's immigration status. So there are several things that you can do. Some involve the prosecutor, some involve the court, but prosecutors, like lawyers, prosecutors want to close cases. I like to go to court, complete my case, and come back to the office with one less file. Why? Because I don't want to keep on going back to court again and again and again for my cases. It's not good business, and the work accumulates. Prosecutors are the same. They have an incentive to close cases.
Well, let me ask you this, because one of the concepts most of us would say in our legal system is we'd want to try to treat everybody equally. And are we giving immigrants benefits or outcomes that normal red-blooded Americans are not getting by virtue of them being immigrants? And is that fair?
That's a good question, and you know, fortunately, we don't have the benefit of having the prosecutor who's going to be on this panel with us. But I think that's a common. Certainly a common sentiment shared by many prosecutors and probably by many persons in general. Why should the approach ever be any different with an immigrant defendant than with a citizen defendant? I think there are a few ways to think about that. One is a different sentence and conviction does not necessarily mean a lesser sentence and conviction. So we've talked about, some of the examples that we've talked about so far sound like it tends to run that way, which is, you know, getting a lesser charge, getting a lesser sentence to avoid the immigration consequence. But in many instances, part of the bargain might be a longer sentence in exchange for a different substantive plea. So just, you know, to take, for example, if you're caught smoking marijuana in public and you're charged with marijuana possession, you as an immigrant defendant might much rather take a plea to disorderly conduct with a longer jail period or a longer community service period than a plea to marijuana possession with no jail time at all, which can happen. So you could actually get a longer sentence as one way to avoid the immigration consequence with a different charge. Another example that comes up is, say, you're stopped for speeding or reckless driving, and the cops find some kind of drug paraphernalia in your car. For citizens, they often would rather have a plea to the possession of drug paraphernalia because it doesn't put points on their license, right? But for an immigrant, you would much rather have a reckless driving charge, regardless of the points on your license, than the plea to a drug-related offense. So sometimes it really is just a different plea. Sometimes it actually is a plea with greater penal sanctions than in order to avoid the immigration consequences. So that's just something to kind of clarify about that. I think to answer the question more, maybe in a different way or maybe more directly, in a way, not considering, here's another perspective on it, I guess, is not considering the immigration consequence that's going to directly flow or likely flow from the criminal conviction means you're not treating, you're treating as similarly situated two things that are not actually the same, right? So for the immigrant, the plea to that involves no jail time to marijuana possession means might mean they're going to be deported or never be able to adjust their status as an automatic consequence of that plea. And for the citizen, the total package of penalties that the Supreme Court recognized in Padilla is very, very different. And so if you're looking at this from a holistic justice point of view, either as a prosecutor or a judge or the defense attorney, in a way you're burying your head in the sand if you ignore the immigration consequences that are going to flow from the plea.
Another interesting issue that I have found, and maybe this question is for both of you, is in particular with domestic violence cases. That is a big no-no in immigration, right? So my sense is that there are a lot of victims of domestic violence who are persuaded not to go forward, not to show up at the trial, so that there won't be this automatic deportation. And so does that then create a chilling effect on the victims of domestic violence, and thereby a law that was intended to improve things for the battered wife or the battered husband, as it were, or the battered significant other, because these very draconian immigration consequences? Does that make sense?
Perfect sense.
You want to comment on that?
That is one of those problems that unfortunately does not have a good solution. And the reason for that is when a female or when a victim of domestic violence calls the police when her husband or partner is a non-U.S. citizen, most victims know what's at stake. And most victims know that if they call the police and their non-U.S. citizen husband gets arrested, there may very well be immigration consequences because they know this by watching TV. They know this from friends who've gotten deported. I mean, in the past few years, deportation in the immigrant community has been crazy. 1 million people have gotten deported, at least statistically, in the past 6 years. So as a result, victims know what's at stake. Now, in some cases, does it have a chilling effect? Absolutely. And they may be willing to stay in an abusive relationship or not call the police because they don't want the provider, the financial provider, to get arrested and get deported. In other instances, on the flip side, sometimes victims call the police a little prematurely, and I see that unfortunately quite often where there is an argument, they are upset at the boyfriend or husband, and they call the police to try to defuse something that perhaps has not risen to the level of a criminal offense, perhaps could have happened, but they call the police. Police arrive, the subject gets arrested, faces deportation, faces custody, and the police were oftentimes called prematurely. And from my perspective, in some of those cases, was a crime committed? No. Could a crime have happened? Perhaps, but the premature arrest results in severe consequences to that family that flow from the domestic violence charge.
Yeah, I mean, I think this is, this is the point at which we might, if Danny was here, have sort of transitioned to asking and talking about the prosecutor's interests in these cases, which are obviously varied or multifaceted, and whether the prosecutor has any duties in these sorts of cases. And just to go back to Padilla for a moment, just before the part that I read before, the court says that informed consideration of possible deportation can only benefit both the state and the non-citizen defendants during the plea bargaining process. By bringing deportation consequences into this process, the defense and the prosecution may well be able to reach agreements that further the interests of both parties. So, does that, it suggests at least that the Supreme Court endorses the idea that prosecutors, like defense attorneys, will be thinking about the proportionality of the immigration consequences that are going to flow from the criminal charge, and through the criminal process, settling on a plea that is the most fair to the defendant and the underlying culpability of their actions. So then that sort of begs the question: what interests should prosecutors be, or are prosecutors weighing when they're approached at the plea bargain stage, or when they're approached at the sentencing stage, or when they're approached at the post-conviction relief stage, in deciding whether and how to help a non-citizen defendant avoid immigration consequences, or perhaps in going the other way and doing everything they can to make sure the person, because of their understanding of the egregiousness of the offense, is going to be removed if possible. So I don't know, do you have, maybe John can speak to us a little bit about these different points of entry. We talked a lot about the plea bargains already, but what sort of values you've perceived from those prosecutors who are willing to negotiate about with an understanding of possible immigration consequences?
I think that comment or that question goes in line with Tony's question a moment ago. Yeah. And I mean, technically, does a prosecutor have a duty to do something to avoid deportation or immigration consequences? I think that I would say probably not. I think that a prosecutor's duty is to prosecute a case in a fair and with the objective of seeking justice. Now, in the process of seeking justice, I think that a prosecutor oftentimes, actually most often, has an open mind as to the immigration consequences of your client's plea if you, the lawyer, bring those potential consequences to the table. The prosecutor sometimes, rarely, they're going to actually be sympathetic without a lawyer asking, but most commonly, if a lawyer brings immigration consequences to the table, and if the lawyer tries to provide a reasonable solution, a reasonable, fair solution on how to dispose of the case in a way that, number one, accomplishes the state's objective of seeking justice and prosecuting the case, whether pretrial diversion or some of the reduction of charges or some of the strategies that I described before, even though it's not necessarily a prosecutor's duty, I think that most prosecutors are very open-minded in trying to tailor a sentence or a resolution that will accomplish both the prosecutor's objective and the defense lawyer's objective. Also, to be honest with you, the punishment doesn't fit the crime perspective is also logical, and most prosecutors, I would say, Danny Porter included. Danny Porter is the district attorney of Gwinnett County. Gwinnett County is not a liberal county, I promise you, in how they prosecute felonies. They are not. However, Danny Porter is actually somebody that I invited who agreed to come. And the reason why I invited Danny Porter specifically is because he is the prime example of harsh prosecution, tough on crime, with an open mind on immigration. And those two things are not mutually exclusive, by the way. You can be a tough prosecutor, and when the case warrants, you send the guy to prison. And I can tell you that there is plenty of cases where immigration is not an objective in my representation, by the way. I represent many clients who are non-U.S. citizens, who I tell them very specifically, dude, there's nothing we can do immigration-wise. You're going to prison. The question is not whether you get deported or not. You will get deported. The question is, what can we do to reduce the criminal consequences of the case? I don't want you to misunderstand. Our presentation doesn't say that your duty is to avoid immigration consequences in every case. That's not correct. Many of my clients that I have represented, I knew they were getting deported from day one. I told them immigration is inevitable. We're not going to be able to cure any immigration issues. You're probably going to prison, and my job is to try to keep you from going to prison. And when you deal with a prosecutor like Danny Porter, he's got a good touch to say, this case is a case where immigration has nothing to do in the equation. This is a prison case. This is a felony where the punishment drives what the prosecutor will do. On many other occasions, when the equities are such, where the level of the charge and the circumstances of the charges are such, the prosecutor, even a harsh one, may be a lot more willing to be flexible and bend on some of the lawyer's requests to reduce charges or do something that will provide immigration benefit.
Now, that's sort of on a case-by-case basis.
Absolutely.
Have you found different prosecutorial offices that have a policy of, being, immigration punitive or immigration sensitive or immigration neutral? I mean, what you've discussed, at least from Danny Porter, is, he'll look at all of these cases on a case-by-case basis. Have you found where there's a policy of, I don't care about immigration, or I'm sensitive to immigration, or if somebody has an immigration issue, I'm going to treat them worse?
Yes. There are some offices that, especially misdemeanor prosecutors, solicitors' offices, that I don't want to say it's a written policy, but in the absence of a written policy, they will present almost every plea to a non-citizen to a sentence of less than 12 months. I mean, there's some offices, I don't want to name any names and make claims for anyone, but I can tell you that several offices, even a pro se guy or a guy that goes in with a lawyer that doesn't have a clue about immigration issues, the prosecutor is going to see that person seems to be a non-citizen, and they're going to offer a sentence of 11 months and 27 days. Now, that sentence doesn't always work to the benefit of the immigrant, because 11 months, 27 days is not a blanket rule that works every time, but there is definitely a desire to help the immigrant from the prosecutor's side in some offices. To the contrary, some offices have the exact same opposite policy. They will not reduce from 12 months to 11 months, 27 days, no matter what, as an office policy, which results in you either having to A, try more cases, B, go non-negotiated and ask the judge to do it.
I'm sorry.
I was going to transition when you say judge, so move
Can I
into
just comment
role,
on
but if
that
you
before
wanna
we do that?
comment on that, yeah.
So, I mean, it's interesting because this has struck me, but knowing what the policy is from the criminal defense attorney's perspective is important, whether or not it's a policy that's going to be immigration neutral or immigration sensitive or immigration punitive. So, for example, you know, if you know that it seems like that if you know the policy at a particular office is, they're going to, not only are they not going to be helpful in an immigrant's case, they might even be more punitive, then part of your duty would be doing everything you can to conceal your client's immigration status, right? And I keep taking that into account. I did want to mention that there are some national standards that do suggest that prosecutors have a duty to consider things like this. The National District Attorneys Association has prosecutor standards. It's a list of many factors that prosecutors are supposed to consider before finalizing plea agreements. And one of them, and many of them have nothing to do with guilt or innocence. One of them is that considering any undue hardship caused to the defendant by the plea. So to me, that seems to encompass this idea that the prosecutors might have at least standards, if not ethical duties, that would allow them to consider that. The American Bar Association has also issued recommendations to prosecutors that they say, quote, to identify a plea to a felony or misdemeanor offense that's roughly equivalent to the one charged, but that's safer for immigration purposes.
Okay, I want to transition a little bit about what the judge's role ought to be in these kind of cases. When I was on the bench, I was on the State Court of DeKalb County, was appointed in 2002. The sentence sheets that we had in DeKalb County read a period of confinement, and it was just a form that they would write 12 months. So every sentence in DeKalb County back in 2002 read 12 months in confinement, and then it had a blank to serve in jail and the remainder on probation. And that was how all of our sentence sheets were drafted when I came on the bench. As I started learning about these issues when I was on the bench, and with John's help, came to realize that there were a lot of pleas that were having immigration consequences when the judges didn't really intend for the person to serve 12 months in confinement. In other words, if somebody had a simple shoplifting where they stole a pack of gum or diapers or milk or whatever, you would give them whatever time served, do a shoplifting diversion class, and 12 months on probation. Well, the manner in which our sentence was written was making all of these folks who were legal residents deportable, when we'd never intended to put anybody in jail for 12 months. And so I actually changed the State Court of DeKalb County's sentence sheet to read a sentence of 12 months, blank to be served in confinement and blank to be served on probation. And that helped, I think, for the immigration issues. But I believe that judges also have a duty to make sure that the record is clear as to what the sentence is, so that there are no problems down the line for the individuals that are pleading in our courtrooms. But that brings us to, what are the duties of a judge? Should the judge care? At the end of the day, I'm here, you want to plea, you want to offer a certain charge. I'm not here to advise or anything like that. So what is a judge to do?
Well, I mean, for starters, the judge does not have any kind of I don't need to tell you this, but any kind of a Sixth Amendment duty, right? The judge's duties in criminal cases flow from other sources. The judge, in terms of the plea bargain process specifically, no?
No, yeah,
Oh, yeah.
I don't get involved in that.
In terms of the plea bargain process, right, judges don't get involved with that. And in fact, there are prohibitions against judges getting involved in the actual plea bargain itself. But judges do have a duty under the Fifth Amendment to make sure that any plea that they take is knowing and voluntary. But of course, this is very distinct from the defense attorney's obligations under the Sixth Amendment. So I think maybe this is a good time to talk about a recent case in Georgia called Encarnacion, and the the reaction of some judges in Georgia and also in other parts of the country to the Padilla rule, and maybe specifically to the Encarnacion rule in Georgia. So,
why don't we, John or Jason or I, tell the audience what the Encarnacion case was and what was told to the individual and what did the court rule?
Well, I mean, at its most straightforward reading, Encarnacion involved a person who was a lawful permanent resident who pled, I don't remember what the charge.
Burglary.
To burglary. And was given the advice from his attorney. This is a case, by the way, from September 2014, so very, very new case. His attorney's advice to him was, this might lead to deportation. And I believe the sentence was something like 2 years. So one of the definitions of aggravated felonies are a crime involving theft plus a sentence of at least 1 year. So in this case, the question was, if your attorney says this might lead to removal, and the immigration charge is going to be an aggravated felony, which almost certainly won't lead to removal, has counsel discharged her duty? And what the Georgia Supreme Court said was no. Yes, there are gray areas, but in situations where the consequences are clear or almost certain, your advice has to be that it's almost certain the immigration consequence that you're going to be deported.
But in that case, even the judge told the defendant that not only could it have immigration ramifications and gave the defendant an opportunity to seek the advice of an immigration lawyer. Is that correct?
If I can expand on that, that is correct. Encarnacion is a post-conviction case, by the way, which is brought to the Georgia Supreme Court as a habeas corpus petition. It is an extension of Padilla, and in a sense, it really is a more stringent or more strict interpretation of Padilla. There's language in Padilla that says that where the impact is clear, the duty to advise is equally clear. When the person is going to get deported, your duty as a criminal defense lawyer is to clearly advise the person that you're going to get deported. Not just that there may be immigration consequences, but rather that there will be immigration consequences. And in Encarnacion, the plea transcript basically showed that the defendant was indeed advised on the record by the judge that you may be deported or that there may be immigration consequences of your plea. There is also evidence on the record that the criminal defense lawyer advised the defendant that there may be immigration consequences of the plea. So from a Padilla point of view, on the face of the plea, it appeared that it was a good plea and that the plea would not be subject to a habeas corpus challenge. Well, Encarnacion reversed actually the conviction and held that the plea was invalid because, once again, citing the language in Padilla, where the impact is clear, the duty to advise on the lawyer's side is equally cleared. In Encarnacion, the guilty plea to a burglary with a 2-year sentence made that person subject to mandatory detention, mandatory deportation, immigration-wise, and as a result, the lawyer's advice should have been, you will be deported. And had that advice been provided to Encarnacion, the plea would have passed muster and would not have been subject to a habeas corpus challenge. Now, before the presentation, all three of us were talking about the positives and the negatives in Encarnacion, and the collateral negative, at least from a practical perspective, is that what do judges want to do? Well, judges want justice most of the time, I would say, but also judges are very interested in protecting their records. Judges hate me when I go back on a habeas trying to undo or vacate a plea. Sometimes they feel sympathy, but I promise they don't like vacating their own pleas. And what Encarnacion has triggered is some judges, not all judges, in an attempt to protect the validity of their pleas or to protect their record, They're taking the advice on the record of telling the person you may suffer immigration consequences to a different level, and now some judges are telling defendants at the time of the plea, you will be deported, which opens an interesting issue that I will let either Tony address.
Yeah, I raised this issue with them. If that is the case, and let's say the judge says you will get deported. Well, let's say that defendant then chooses to go to trial because they don't want to be deported, and they get convicted and get a very lengthy sentence. Well, if it turns out that what the judge told them was not true, that in fact they wouldn't have been deportable, does that give the criminal defendant an avenue for post-conviction relief?
Jason, me?
I don't know the answer to that. So the question, I mean, there are a number of
maybe you were thinking of another issue that we discussed.
Well, there are a number of things that flow from this. I mean, so one question is, if a judge, can a judge cure a Padilla violation through a blanket advisal to a defendant by saying you will be deported? Does that discharge the defendant's own attorney from their obligation to individually evaluate the consequences of the conviction for that person under the Sixth Amendment? Or does it insulate, or even if it doesn't discharge that duty, does it insulate a post-conviction review where it turns out, where the person does end up in deportation proceedings, wants to go back and reopen that conviction, but the judge actually said, hey, you will be deported. So that's one way to look at this.
There's a great case that I hated initially and that I grew to love by the name of Smith v. State. And Smith v. State is a 2010 Georgia Supreme Court case that came 3 to 4 months after Padilla, and that is it's related to Padilla. And the case provides a very good distinction between the judge's duties under the Fifth on a plea colloquy to inform the defendant of the immigration consequences of the plea versus a much higher lawyer duty under the Sixth to provide effective assistance. So I think that that case kind of provides not an exact answer to Tony's question, but it does outline that the judge's statements during the plea are going to be held at a lower standard for purposes of post-conviction relief than a lawyer's misguided advice. If I pursue a habeas corpus, I am looking for ineffective assistance of counsel all day long over a judge's statement that may not be correct, because I will be subject to an easier standard to meet on a habeas under the Sixth than under the Fifth under a judge's lower duty.
So in other words, if the defendant, this was Tony's hypothetical, that if a defendant is told by their counsel, you're probably not going to be deported, you have good chance for discretionary relief, and then the judge says to the defendant at the plea, you will be deported, and then as a consequence, the defendant elects to go to trial, ends up being convicted, and now it sounds like what you're saying is it would be very difficult for an attorney to go back, reopen the plea after having been convicted at trial based on the judge's Fifth Amendment violation, if there was one.
That is absolutely correct.
So that's one scenario that's troubling, and then the other one is the one that I outlined, which is that the person may be receiving inaccurate advice from the judge, but that it differs from what their counsel has done. And I mean, I think I'll just lay out there a few of the considerations as to why this is problematic, and I think we won't be able to come up with a definitive legal answer here as to whether a judge can insulate a plea or not. First of all, I mean, Padilla is, there is a helpful piece of Padilla in thinking about this, and that is that Padilla explicitly rejected the idea, and we talked about this before, that the Sixth Amendment duty only encompasses misadvice, right? The Padilla was very clear. Not only does the defense attorney have to give accurate advice if they choose to give advice, but they actually have to do the investigation and give the advice. It's not enough to stand by. The concurrence in that opinion would have held that the Sixth Amendment only covers misadvice along the lines of the Georgia Rollins case that we discussed earlier. So in a way, this, if a judge can correct an attorney's misadvice or non-advice, then it takes the it really takes the importance of PIDEA away, because it means that an attorney could walk into any courtroom and say, "Judge, I actually decided not to investigate this one," and the judge could say, "Well, I better tell the defendant you will be deported to insulate this plea." And I don't think that would hold up at the Supreme Court if this is to get there. But the other thing I just want to mention is that it creates these judicial advisals. Create other problems potentially. So if you're standing there with your attorney, and John can speak more about this, and the judge is telling you you will be deported, and your attorney has advised you, well, you're deportable, but you're going to be eligible for discretionary relief, then you're in a difficult situation right there in the courtroom that might put your attorney in the position of having to reveal client confidences on the record, potentially incriminate yourself under the Fifth Amendment by revealing your status as part of this colloquy, and because your immigration status is actually potentially, it's an element of certain federal migration crimes like illegal entry and illegal reentry. And so it may have these unintended or these additional consequences that are problematic.
Anything else to add, John?
I've actually encountered a couple of judges in the past couple of months after Encarnacion that actually did in fact tell my client during the course of a plea that you will be deported as a result of the plea. And I had to correct the judge and very respectfully say, Your Honor, you are correct that there are immigration consequences of the guilty plea, but I've got to tell you, as an immigration, let's say knowledgeable defense lawyer, that there is immigration relief, and that in these circumstances, although there are immigration consequences that flow from this plea, that is not correct, and my client is very eligible for immigration relief. One of the judges was bothered by my response and attempted to correct the record and say, Mr. Sperling, that may very well be, but I am telling your client that he may get deported. I'm sorry, that he will be deported. And once again, I had to kind of go back and a little uncomfortably and say, once again, Judge, I know for a fact that that is not correct, and my client is entering a plea knowing that he is eligible for immigration relief, and that is part of the consideration for us not going to trial. In the end, the plea went through, but it was a lot more difficult to make it happen. And in the other circumstance, the judge said, well, Mr. Sperling, thank you so much for letting me know that. And, I'm glad that there is immigration relief available to your client. I'm trying to protect my record as a judge. And I said, Your Honor, that's great, but you've got to be careful addressing Tony's concern in saying that to every person that takes a plea before you, because you may end up derailing some pleas that are very beneficial to the defendant, where there's an agreement with the state that was specifically tailored, and if the client hears from the judge, you will be deported, no matter what I say. Sometimes I lose credibility with my client, where I know a hell of a lot more than the judge as to immigration-related issues. So that is also a challenge, because you want credibility from your clients, and when the judge is undermining your advice, not really knowing what he's telling the client, purely to protect the record, it makes it more difficult to help the client the way that you want to.
Right, and so in that circumstance, when I was on the bench, I told every criminal defendant that came in my courtroom that if you are not a United States citizen, this plea could have negative immigration ramifications, and then I gave them an opportunity to speak to an immigration lawyer if they wanted to do that. Now, in the circumstance that you're talking about, with the judges telling them that they will, is that an ethical problem from the judge's perspective? Because the judge doesn't necessarily know that will happen because that determination will be made by somebody else. So is the judge fulfilling his ethical obligations by giving that advice to every person? I mean, if you say as a judge, it may have, I think I can tell that to every person that is not a U.S. citizen, it could have negative immigration ramifications. But when you say you will be deported, that seems to be that it's going to be incorrect in a number of circumstances, and if the judge doesn't make himself aware of those circumstances, is the judge somehow creating a problem or acting in a way that's not necessarily ethical? Does that make sense?
I would say that yes. OCGA 17-793C was implemented in 2000, and it is a statute that requires the courts to advise a non-U.S. citizen that there may be immigration consequences that flow from their plea. I think that that statutory provision is what a judge should do. Correct. I think that that is the ethical way that a judge should handle the plea colloquy and should defer pursuant to Rollins, Padilla, and now Encarnacion to the counsel, to the criminal defense lawyer's ability to advise the client properly. I think that a heightened level of advice is improper.
Right, so you would not agree that a judge has to say that you will be deported?
I do not agree with that at all.
Jason?
Yeah, I think it's really problematic for some of the reasons that we've been talking about. I mean, I don't know whether there are sort of ethical constraints that would prohibit reckless advisals from a judge. It seems like perhaps that would interfere with this idea that the plea is knowing and voluntary in some ways, but I haven't researched that. But it certainly creates these other ethical problems. So even, in John's examples from his own practice, even the fact that this had to lead to a conversation on the record in court with the judge that the person is probably going to be eligible for discretionary relief is revealing client confidences in a way that they're not supposed to be revealed, and the person's, it sort of implicitly acknowledges the person is not a citizen, and that again that could create Fifth Amendment problems as well. That record could then become the basis of a federal prosecution for an illegal reentry case. So I think that's incredibly problematic, and I don't know what exactly what the remedy is for that kind of advisal. I mean, in general, you probably use language like this, John, but in general, when a defense attorney is creating a record for a plea, they'll say something like, "I have advised my client, as to all the attendant consequences, and the client is relying on my advice," which is a very careful way of making sure that the record is clear, that the person is pleading voluntarily and knowingly, without revealing confidences that even could lead to further prosecution.
Yeah, but I am troubled by your example, John, because most clients, I would imagine, and I don't do criminal law in my practice, but your client is going to believe that the judge probably knows more than the lawyer.
Unfortunately,
and so if a judge is telling you this, then I'm thinking, what is my lawyer telling me? Because he's the judge, he's sitting up there. I mean, that creates client relationship issues as well, does it not?
Absolutely, but more importantly, it makes the client, it definitely jeopardizes the lawyer-client relationship, but it really creates a bigger problem. If I'm an expert in representing a non-U.S. citizen, and I am doing the best that I can to safeguard that person's immigration status, not only does it jeopardize my relationship and my credibility from the client, but even though it hasn't happened yet under that scenario, I could potentially get fired by the client,
right,
and the client could end up hiring somebody else that knows nothing about immigration, that would follow that lawyer's advice and say, oh yeah, you'll be deported, when that is not correct, and end up getting a result that will absolutely get the guy deported.
Or it may be the case that that guy ends up going to trial, gets convicted when they would have had relief otherwise.
Absolutely. Or failed to ask for something that I had requested previously that was part of the negotiated plea, and end up fulfilling the judge's prophecy of you getting deported, which is not what we were trying to accomplish to begin with.
Now,
that is the bigger problem.
I mean, interestingly though, at this stage, at this plea bargain stage, when you've worked out your deal with the prosecutor, the state's interests and the defendant's interests are very aligned. I mean, this is where what John was talking about before. Everybody wants this case to be off their table, and so perhaps it's you know, in terms of just advocacy around the issue in general, it's an area where prosecutors and the defense bar might be able to kind of collectively work together, at least in some states or some jurisdictions, to think about this problem. Because prosecutors don't want the plea deal to fall apart at the last minute because of erroneous advisals from a judge, right? And the judge's advisals are either going to be correct or not, but they're not going to be based on anything, because the judge is not going to do any kind of individualized, and cannot do any kind of individualized inquiry into the person's actual immigration status or the consequences that will flow for that particular person.
All right, we have just a few more minutes left, and I did want to leave some room for some questions. If any of you have any questions of our expert panel, we're happy to take them. Yes, sir.
Can the defendant waive their right to do it as a defense attorney if you say, client, we understand this could impact your immigration status? Under the 2014 case, and you say, I advise him to go and speak to an immigration lawyer, they understand that has impact. Can they therefore waive it so it doesn't become an issue under affirmatively telling your client that it will impact their immigration status in the United States?
John.
Can you outsource the duty? Is that sort of the question? That can you?
Well, it's a waiver issue. I mean, I think what he's saying is that if the lawyer tells the client, you know, do you want to talk to an immigration lawyer before you enter this plea, and the client says, no, I'm good, I know I'm going to be deported, I'm fine, does that fulfill Encarnacion's duty, the holding that the lawyer has to give the right advice?
I'll say this. It goes back to when I was talking earlier about a lawyer's duty. Let's say that you represent a young lady on a shoplifting charge, and you tell that young lady you're getting 12 months probation and you will be deported, okay? If you tell that person you will be deported based on your 12-month sentence, from a technical perspective, you are satisfying, I would say, Encarnacion and Padilla, because you are affirmatively advising that person that they will be deported. From a practical perspective, what if you could have gotten pretrial diversion and gotten the charge dismissed? What if you could have gotten a criminal trespass reduced from shoplifting? What if you could have gotten an 11-month probation sentence that would have saved her status? Number one, I would say if you could have avoided it, you would feel terrible for not doing so, right? But really, Padilla and Encarnacion, I don't think raise your duty to the level of having to avoid the immigration consequences of the plea. What I can tell you is that if I went to a prosecutor, and 30% of what I do is post-conviction work, I do a lot of habeases, and let's say that I got a plea transcript where you pled somebody to 12 months shoplifting and you told them on the record you will be deported. From a legal perspective, I would probably lose the habeas because technically you would have satisfied your duty under Padilla and Encarnacion. From a practical perspective, I can tell you that 99% of prosecutors would agree with me and say the lawyer was indeed ineffective, because I know that I would have given a lesser charge, or I know that my judge would have given a lesser sentence, so as a result I will get that plea vacated very quickly, not specifically under the language of Padilla and Encarnacion, but I will get that plea vacated very quickly from an equitable, ineffective perspective.
But I think, though, your question is a little different, and I think that issue was addressed in Encarnacion, because in Encarnacion, the defendant, as I remember the case, was told that they had the ability to go talk to a lawyer, and they said no. So if you take that to its logical conclusion, then a lawyer's offer to have him go talk to an immigration lawyer and them saying no would not act as a waiver, I wouldn't think.
I think that's very clear.
Right, right. I mean,
But a lot of felonies, you know, if you know that they're going to be deported, you don't know everybody's immigration status at that point and trying to make sure that they're covered. So they will be deported. You know, I've advised them it will have an impact. However, they need to speak to individual counsel. That satisfies for the NA.
well, yeah, that satisfies it by you telling them they will be deported, right? So you've satisfied it that way. It's only when they say it may have immigration ramifications, and you say it may have immigration ramifications, so you may want to talk to an immigration lawyer, that you potentially run into the Encarnacion problem of not giving the right advice. When you know that it's almost a certainty, as the court said, you know, death and taxes, everybody knows you can't get away from. Just like deportation, you probably can't get away from that type of offense.
But just to be clear, the fact that something is a felony
Right.
does not mean it's going to be an aggravated felony, right? And so your duty, the Sixth Amendment duty, would not be discharged for you to say, because this is a felony, you're going to be removed, right? I mean, you have to, because it's federal, I mean, a state felony is not necessarily going to line up with the corresponding federal felony that will trigger the immigration consequence.
Yes, ma'am.
Thanks. I'd just like to add a comment on that, we're talking about what's going to happen with a conviction in court. There's also the lawyer's ethical duty. Are you living up to your ethical responsibility to competently practice law? And if your client says, nah, I'm good, I don't need to go, after what you've learned today, are you comfortable saying, sure, that's fine, that's good enough, I can competently represent you without you or me knowing that there may be an immigration consequence we could avoid?
Along that point,
out there.
Along that point, I think becomes a lawyer's duty to contact the immigration lawyer. If the client is not willing to go and consult with an immigration lawyer, it becomes the lawyer's duty. And I promise you, I do it all the time. I will call an immigration lawyer and say, I'm pretty certain that I know the answer to this question, but just to be on the safe side, am I correct? And at that point in time, I've satisfied my duty.
Anybody else? Yes, sir.
My understanding is that Encarnacion only addresses the deficient performance prong of ineffectiveness.
Speak up a little bit.
My understanding is that Encarnacion only addresses deficient performance.
Right.
How would you show prejudice for a client who's willing to plead guilty knowing there may be immigration consequences and showing there's a reasonable probability that he would not have pled guilty if he knew definitely that there would be negative consequences?
For every habeas challenge, and you're absolutely correct, it's a two-pronged test under Strickland v. Washington. Prong number one, you've got to show that the lawyer was ineffective and that his conduct fell below the standards of other lawyers, right? Prong number two is the actual impact that but for the lawyer's misrepresentation or ineffective representation, the outcome would have been different. In my experience, that's typically going to be an easy prong to meet. I may do it by getting an affidavit from the client, to be honest with you, which would be the better way to do it, not to put the guy on the record subject to cross-examination. And I'm going to get an affidavit from the client. There's some filing requirements, but I will file the affidavit 10 days prior to the habeas hearing, and the client will say that had I been informed accordingly, I would have never entered a guilty plea and I would have gone to trial. I've had maybe in 15 years 2 or 3 habeas hearings where I was challenged pretty aggressively by the prosecutor on prong number 2, and I was fortunate that all 3 cases did in fact provide a defense to the underlying charge, which I'm not going to file a habeas, to be honest with you, when a guy was convicted. Even if I have a good Padilla claim or a good Encarnacion claim, I am not going to file a habeas where I know that even if I vacate the plea, the client is going to end up in the same position or a worse position. I would be really taking the guy's money. What I'm going to do is I'm going to talk to the prosecutor before I file the habeas, and I'm going to know what is going to happen on the back end if I vacate the plea. And I will only pursue pursue vacating that plea when I know that there was a legal defense to the underlying charge to begin with, because at that point in time, if I vacate the plea, I'm going to have leverage on the back end, either on a motion to suppress if it's a drug charge, or on a triable issue if it's another type of crime.
Or they might be willing to negotiate the case with you at that point, you know, and you would know that ahead of time because, you know, careful what you ask for, you might just get it.
I mean, it's interesting, even in Padilla, the Padilla case itself, Jose Padilla, his charge was he was a truck driver and he was discovered with like 1,000 pounds of marijuana in his truck.
Is that wrong?
Is that all?
Is that wrong?
Shouldn't be.
And you know, when the case was remanded, a lot of people raised this question of how, you know, how is he going to establish prejudice? And in fact, he did, because there were defenses. Maybe he didn't know the contents of the truck, and so when it was remanded and it went back to the Kentucky Supreme Court, they did find that there was prejudice there too, despite that the gravity of that charge.
Yes, ma'am. Last question.
Immigration lawyer, or you practice immigration law, and you have a client who is the victim of domestic violence, even if their husband is undocumented, there is relief in the form of a U visa for victims of crime. Sure. And so they don't have to be afraid of, well, if I prosecute this person, are they going to deport me? No, if you meet the qualifications for the U visa and you can get the prosecutor to verify that you've been helpful in the case and the prosecution of this person, you can get a U visa and get residence in that method.
That's absolutely correct.
Even if you're undocumented and you came in illegally.
That's correct. We were actually looking at it from a different perspective, which is the domestic violence victim who does not want the abuser necessarily to be deported. You know, in many cases, many courts now deal with domestic violence charges through diversion programs and treatment and counseling type programs, alternatives to incarceration. But for victims of abuse who are the abuser and their partner, and in most cases the breadwinner of the house is undocumented, they are in a bind if they want to sort of end the abuse, potentially, but also potentially stay with this person and not have them deported and not become dependent on public services or, you know.
It's a very difficult issue.
Difficult. So it's a difficult situation. Yeah.
Okay. Well, thank you guys so much for coming. Allow me to say thank you to my panelists, and thank you for being here, and let's give them a big round of applause.
The preceding program is copyrighted by Emory University.